Oh, I see. Okay, and it's not to continue. Okay. All right, are you Kashawn Pugh? And Mr. Parker, will your client waive the formal reading of the motion and the indictment?
You will, Judge.
You, in cause number 23, DCCR 1531, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from June 18th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In that case, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? And do you fully understand them? Answer out loud, please. Thank you. The court reporter has to take everything down. And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. And Mr. Pugh, you are a U.S. citizen, correct? Is there any evidence that Mr. Pugh is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 19, 33356, give me just a second. Yeah.
Kim just realized we have Adams. I don't know if you need it or not since they came up with something.
No, not since they came up with
Okay,
something. Thank you, though.
Yes, ma'am.
Actually, let me see that again. No. What I'm looking at right now is your jail incident reports. You don't like being told what to do out there, do you?
That's not the issue. People come to work with problems of their own.
Okay, so it's the correctional officer's faults that you don't follow the rules?
When I walked across the dorm to give a guy his bowl, I did that. I was working out in the bathroom, I did that.
Okay,
Miss Painter, she called me on my name multiple times and I asked her to identify herself. The other things that she wrote in there about me were not true. I had another officer read it to me so I know what it says.
okay. There's only one.
Mr. Washington wrote me up, and that was a lie. That's why I got moved to orange, because I actually was in blue at first. And the lieutenants don't even know why I was in there. I was actually in dorm, placed in dorm under, so to say, Stroder's advisor, but Stroder never wrote me up, so I don't even have a write-up for that.
Okay.
They don't have that in there either.
Okay. I mean, it sounds like you're saying you did most of what they're saying you did
No, I
wrong
didn't do
anyway.
most of what they're saying at all. Most of those write-ups, Washington and Painter, and I think another lady, I didn't do the other things that she wrote up. Butte wrote me up for some other things, and I told her that I can't do her job for her. She wanted me to point somebody out, and that was it. She just wrote me up on it. So.
Okay. So Washington didn't tell you to stop talking,
No,
and
he
you
didn't.
responded by saying, quote, "Officer, you telling me we can't talk in the bunk area? You tripping." You didn't say that?
I did not. That man did not tell me nothing that whole day. He didn't. And when I asked him if I had a write-up, he told me no. And they actually wrote me up 2 days after they moved me from blue to orange. That wasn't even the same day.
And you didn't go to the restroom and wash your clothes in the sink and he
No,
told
ma'am,
you
I
not to
did
do that?
I did not do none of that.
You just made all that up?
I swear, I asked the lieutenant to check the cameras and see if that's what I did, and she didn't want to do it. So that write-up was just for nothing. When I asked him if he wrote me up because they told me that I had a move card, I said, why am I moving from blue to orange? He said, I don't know. And I was like, well, did you write me up for something? He said, no, I didn't write you up. The lieutenant called and said that you had a move card, that they was placing me in my right because I have a felony case that I'm supposed to be in orange. And when I came in at first, I told them that I was supposed to be in orange, but they put me in blue and told me that they were.
Sounds like you know their job better than them, huh? You're just out there telling them what to do and where you're supposed to be and all that kind of stuff. See, here's the thing. I don't have to accept any agreements in here. And I know word out there, it's got to be getting around that I'm not accepting agreements. I'm putting people back in jail because of these incident reports. Because these people are just trying to go to work and do their job, and they don't need you or anybody else telling them how to do their job, where you're supposed to be. You're supposed to be where they tell you to be. You're supposed to wear what they tell you to wear. That's part of being in jail. You don't get to make your own rules. Stop breaking the law and you can do what you want and wear what you want when you're out. Does that make sense?
It does make sense.
All right, so in cause number 19-33356, I have a motion to revoke your unadjudicated probation. This one shows that you're placed on probation December 7th of 2020 for unauthorized use of a motor vehicle. That was a 2-year probation. Looks like it was extended at least once. Is that correct?
Yes, ma'am.
Okay.
It looks like this motion, Judge, was filed in 23, so that needs to be worked a little bit. He's just been at large on it since.
Okay. It alleges that you violated your probation. Count 1 alleges that you committed the new offense of evading arrest, June 18th of 2023. And is that true or not true? True or not true? True. Count 2 alleges that you failed to report as directed to the probation department April 10th, May 22nd, and June 12th of 2023. And is that true or not true?
True.
Count 3 alleges that you didn't work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
I'm sorry?
Not true.
Okay. Count 4 alleges that you failed to immediately report to the probation officer a change of address and your arrest. Is that true or not true?
Not true.
Count 5 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
Count 6 alleges that you failed to provide verification of participating in the education program for your GED. And is that true or not true?
True.
Count 7 alleges that you failed to provide verification of paying court-ordered child support. Is that true or not true?
Not true.
Count 8 alleges that you're behind in your court-assessed fees as of June 26, 2023, in the amount of $2,361. And is that true or not true?
That's true.
So he was at large since 2023? Is that what this, I would assume from this? Since there's,
That's what I would assume, Judge, just from the file stamps and the fact that his last admin was in 23 as well.
so did you just stop going to probation back in 23?
Yes, ma'am.
That's after he got arrested on the new case, apparently. But that's what it appears, Judge.
No, that was before I got arrested.
Yeah, the new case is from March of 2024, so you had already stopped going for
Yes,
almost a
ma'am.
year.
Because she was planning to violate me for
This
any
is-
reason. I don't know why.
It says June 18th or 23, I thought.
I'm sorry, I'm looking at the wrong thing. Hold on. Looking at the wrong thing.
He was supposed to report.
2023, June 18th, yeah. Stopped reporting in April. New offense in June. I don't know if I like it or not. Guess it really doesn't matter a whole lot just because it's gonna, I already gave them the 3 on the other one.
We can rediscuss it, Judge, and raise the time.
I'll do it. All right, so I'm going to find that you entered your pleas of true to counts 1, 2. Well, let me go through this first. I have also in this case, on the motion to revoke case, some documents here on the computer that have your signature on them. Did you also go over these with Mr. Parker?
Yes, ma'am.
And you fully understand them?
Yes, ma'am.
Again, you understand if I follow this agreement that you'll be waiving or giving up any right to appeal.
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. All right, I'm going to find that you entered your pleas of true to counts 1, 2, 5, 6, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a motor vehicle. Sentence you in accordance with your agreement to a term of 1 year in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certifications in each of these cases that shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, you can go back with the bailiff. Good morning, sir. You're Juan Sanchez?
Yeah, ma'am.
And this is cause number 18-30854. We've got a motion to revoke probation. I guess set for an announcement. Were y'all, before we go any further, were y'all able to work out getting everything discovery-wise, that anything that was an issue?
Yes, Your Honor, we've received discovery and I've reviewed it.
Okay, perfect. And so what is the announcement?
We are ready to proceed.
Okay, and so there's no agreement?
We haven't really discussed that. I don't think he's going to accept any revocation offer, Your Honor.
All right, so what we can do is just go through that motion, get pleas of true or not true, and then we would reset it for a hearing on sentencing, get a pre-sentence report update done. Does that sound like what we need to do?
I think so, Your Honor.
All right, let me get this.
Yes, Your Honor, he does want to stay. I just checked with him this morning again. He wants to stay on probation.
All right, so we'll go through that motion. Let me get it pulled up the right way. Mr. Sanchez, the best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Speak up, please.
Yes, Honor.
Thank you. And will he waive the formal reading of that motion?
Yes, Your Honor.
Let's see. All right, Mr. Sanchez, I have a motion to revoke your community supervision. Shows that you were placed on probation September 30th of 2019 for the offense of driving while intoxicated, a third-degree felony. That was an 8-year sentence in prison, but it was probated for 10 years. Is that correct? I need everyone to please hold it down. If you're talking to a DA, that's fine. Everyone else. Mr. Sanchez, is that correct? Okay. Thank you. Count 1 in this motion alleges that you violated your probation by committing the new offense of driving while intoxicated, third or more, April 15th of 2025 in Wharton County, Texas. And is that true or not true?
Yes, Honor.
That's true? Okay. Count 2 alleges that you failed to provide verification of having the auto ignition interlock system on your vehicle. Is that true or not true?
Yes, Honor.
It's true. And then count 3 alleges that you failed to never become intoxicated or under the influence of an intoxicating substance, and that you were intoxicated April 15th of 2025. Is that true or not
Yes,
true?
Honor.
It's true. Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily? Okay, and did you plead true to those counts because they're all actually true? Okay, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do that today. I'm going to reset your case so that the probation department can do an updated report and give me more information about what's been going on probation and all of that. And then we'll come back at a later date for sentencing. If there's anything that you think is important for me to know, get that information to Mr. Franklin and he will present it to me on your behalf when we come back. Do you
I
anticipate
don't
any
see-
witnesses
with
or
the-
anything?
With the plea to true, Judge, I'll just wait and see what the report has to say.
Okay, sounds good. We'll reset it for sentencing. Thank you.
Thank you, Your Honor.
Oh, we need to get his fingerprint while he's here, please. Unagreed, yes, ma'am. Let's see. Pull this up.
Oh, cool.
All right, this is cause number 23, DCCR 0167. And are you Courtney Joseph? And so Ms. Joseph is on probation for assault on a peace officer. That probation started on December 11th of 2023. It was a 5-year deferred probation. A motion to revoke that probation has been filed with allegation of driving while intoxicated with a child passenger. I guess there must have been at least 3 of those passengers because there's 3 charges. Violation of committing the offense of resisting arrest. Allegedly left the county and was in Orange without permission. Out past court-ordered curfew. The new offenses alleged were at 10:17 p.m. in Orange, it looks like, yeah. And behind on fees. And Mr. LaGroppe has filed a motion asking that I set a bond. It is a deferred probation, so typically a bond would be set depending on certain circumstances. So Mr. LaGroppe, I will go ahead and let you want to call your client, or if you would, ma'am, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you.
And I'm just gonna question her about her financial circumstances.
That's fine.
Okay, how long have you lived in Jefferson
Since 22. August
Speak up some for me and for the court reporter, please.
August 2022,
County? Where did you live before that?
in Orange, Texas.
How long did you live in Orange, Texas?
Almost 2 years with my grandmother
And where did you live before you lived in Orange, Texas?
in Courtroom
Hold on. How long did you live in Hold on?
for 3 years.
Let me ask you this, where were you born and raised?
Orange, Texas.
So you've lived in the general area of Jefferson County, Orange, Texas, and Port Arthur since you were born, huh?
Yes.
Okay. Have you ever moved out of state or anything like that?
No.
How many children do you have?
I have 5
And where do they all live?
with me.
What type of work were you doing when you were on probation?
I was care provider.
Care provider. Explain to the judge what you mean by care provider.
I provided for an elderly man. I cook, clean, 3 hours, 3 hours a day, 5 days a week.
How much money were you making with that?
You just $8 an hour.
How much money approximately would you make a week?
How much it's worth? So like 140.
And so you make about $140 a week?
Yes.
So you would total about $600-700 a month?
Yeah.
Okay. Where do you and your children live?
On 8th Street.
Do you live with your family or do you live by yourself?
Me and my children, my mom just moved back in.
So your mother just moved back.
Yes.
Before the allegations that are alleged in the motion to revoke probation, who were you living with at that time?
Just me and my children.
Okay. You and your sister?
Me and my children.
You and your children. If you're only making $600 a month, how are you paying rent where you live?
I also get Social Security survivors. My children's father had passed into me.
And how much money do you get for the survivors?
$780.
$780 a month. Okay. And approximately how much money do you have right now in the bank?
I have
No? Okay. If the,
I have something. 15.
Speak up.
I get paid around the 15.
How much money will be coming in?
780.
And so, if the court were to set bond at a reasonable amount, okay, would you show up for your court appearances?
Yes.
Okay. You understand the allegations against you, right?
Yes.
Okay. And you're gonna have to appear in Orange County, correct? I mean, what's the county of Orange? I can't.
Orange.
Orange.
Mhm. It is.
I should know that. Orange County, so what was your bond set out in Orange County?
3,000.
What? Okay, 3,000. So, and did you post that bond?
Yes.
Okay. Have you had to show up for court yet for that yet?
No,
When is your next court appearance for that?
I have no idea. I was calling every Monday like I was supposed to, and then when this one came in, I turned myself in.
Okay. And once you found out, you talked to your probation officer, they told you they were gonna file a motion to revoke, right?
Yes.
And you reached out to me, correct?
Yes.
And then and they had to schedule a meeting for, I think it was July 31st,
The 31st, 49.
and you turned yourself in the day before,
Yes.
correct? Okay. And you knew you were gonna be arrested if you came.
I'm pretty sure.
Okay, I pass on.
Any
I
questions?
have no other questions for purposes of this hearing, Your
All
Honor.
right, any other witnesses?
No.
Mr. Nichols, what's the state's position on
I
this?
don't mind the court setting a reasonable bond in this case, Your Honor. I just want there to be sufficient conditions in place to keep her from driving, and she needs to, I think, have an alcohol monitor of some sort. I'll note, all these violations except for the fees and stuff, all of one incident, there's not a history of testing positive or anything like that. So whatever the court sets is fine, as long as we have those restrictions that we need.
Okay.
Can I elaborate?
Yes, sir, please.
Very minor amount. Her mistake was she went to a family gathering. That's why she left the county. That's why she left to go to a family gathering with all her children. That's wherein the rub lies.
Yeah.
Bad judgment, Your Honor.
Very. Especially while you're on probation for a second-degree felony. So what I'm going to do is grant the motion. I'm going to, is there an order? I'm going to,
I'll follow.
okay. Let me look at one thing real quick. Original bonds. I'm gonna set your bond at $20,000. A condition of that bond, if you make it, will be that you will be required to wear a SCRAM device. And that is a monitor that you wear on your body at all times that will alert if any alcohol is consumed at all. Obviously, you will be ordered to remain in Jefferson County, Texas. Just like before, if you leave Jefferson County for any reason without permission, your bond, we're not gonna be talking about a bond again. You'll just be sitting in jail waiting on all of this. Do you understand?
Yes.
If you test positive for alcohol, then you're gonna end up right back in here. Do you understand that? Anything else?
I think that's sufficient, Your Honor.
All right, well, if, we'll reset it for a regular announcement and see where we get at that point,
And
all right?
I'll draft.
Okay, thank you, sir.
Orders.
Thank you.
You can just email it to me.
Mr. LaGroff, if you want to just email the order. Good morning, are you Ronald Spites? And Mr. Spites is charged with the offense of manslaughter in cause number 25 DCCR 0920. Mr. Macon has filed a motion asking me,
No, he was arrested for murder, indicted for manslaughter.
Intentionally and knowingly causing the death of an individual.
let me look at the indictment. It shows, I don't know why the heading
Heading says manslaughter, but the language.
did then and there
knowingly, not
intentionally
recklessly.
and knowingly caused the death of an individual, namely Rowan Williams, by striking him with an automobile. So at least on the indictment language, that would be murder. I know it's not, the headings are not sometimes important, but I think that needs to be adjusted and changed, especially if that is what is in, that's what's in Odyssey. So that's showing up on everything with the wrong stuff, so that needs to be amended if you can. Take care of that later. So, based on that, it looks like the offense is actually the first-degree felony offense of murder, Mr. Spites. And Mr. Macon has filed a motion asking that I reduce your bond. Did I print? No, I'm printing it now, the PC. Bond is currently set. Sorry, I've got too many things I'm thinking about trying to do right now.
It's $800,000.
Thank you. Currently set at 800,000. Mr. Macon, do you wish to call your client?
Yes, Your Honor.
Sir, if you'll please raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Macon.
Now, what's your name?
Ron James Spike.
And Mr. Spikes, you're the person charged with the offense. Okay?
Yes, sir.
Do you have enough money, you or your family, to post a $800,000 bond?
Yes, sir, I do.
Okay. Now, before you were arrested, I mean, in the past, you were in lots of trouble, right?
Yes, sir.
And you've got some priors. What, in the last 10 years, have you been in any trouble?
No, sir, I have not been in no trouble.
Okay. And you have your wife living in this area?
Yes, I have my wife, my family, and things.
Okay, and your family, and you have a job, were you able to make bond?
Yes, sir.
And that's with your father-in-law, Mr. Gonzalez,
Yes,
correct?
sir. Yes, sir.
And that's at 365 SCRAM?
Yeah, yes, sir.
Okay, and did you also work for Zachary as a heavy equipment?
Yes, sir, I do.
So you've always been working and all?
Yes, I have,
Do you
sir.
have any assets whatsoever? Real property, coin collections,
No,
anything
sir.
like that? And you're asking the court to set some reasonable bond so you could get out and go to work?
Yes, sir.
Mr. Smith, any questions? All right, any other witnesses?
No.
Mr. Smith, what is the state's position?
Judge, he does have a prior from 1998, where he sentenced served 4 years TDC. So whatever if it's murder, he would be 15 to life at least. And if it's manslaughter, it's 5 to life. State court is reasonable for us.
Mr. Macon?
Your Honor, we think that $800,000 bond is excessive and would ask that it be lowered.
I am taking judicial notice of the court's file, which includes the probable cause affidavit, as well as there was a letter of support that was sent by Mr. Macon from a Rocky Johnson. Were you able to review that, Mr. Smith? I think it was emailed.
I believe it is.
Okay. Let me take a look at this real quick. And the prior was from when? 90?
98. November 16th.
Okay. Speak up, please.
It was from November 16th of 1998 for a 4-year sentence.
All right, 2, possession of controlled substance, same date. Got it. Okay. What I'm going to do is I am going to grant the motion for a bond reduction. I'm going to reduce the bond to $500,000. Sir, did you want to say that again louder? You did say something.
Well, I didn't say nothing to it.
I'm going to reduce the bond to $500,000. A condition of that bond would be, if you make it, that you are on house arrest and required to wear a GPS monitoring device at all times. and we will get the case set for an announcement as quickly as possible. All right, sir? That's what it's set at right now, all right? You can go back with the bailiff.
Can I ask one question too?
What?
I think Mr. Sorry. Philip said that the discovery exhibit for one of those is being sent by Sarah since I didn't have it.
Oh, okay, thank you. Thank you, Mr. Smith.
Sorry.
All right, are you LaCaven Jenkins?
Yes, ma'am.
And Ms. Perazzo, will your client waive the formal reading of the indictment in each case? Mr. Jenkins, in cause number 24, DCCR 1026, you're charged with the first-degree felony offense of aggravated robbery, and that is from March 3rd of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then, in cause number 24, DCCR 1027, you're charged with the third-degree felony offense of fraudulent use or possession of identifying information from March 12th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? Answer out loud for me, thank you. And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents in each of those cases that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Perazzo?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Jenkins is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 24, DCCR 1026, find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Let's see, is there a, I am making an affirmative finding of a deadly weapon in that case. And then in cause number 24, DCCR 1027, also find sufficient evidence to find you guilty, and at this time find you guilty of fraudulent use or possession of identifying information. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Perazzo.
Yes, ma'am.
All right, good luck to you, sir. You can go back with the bailiff. Thank you, Ms. Perazzo. I'm good. Good morning. All right, sir, you are Tyron Henderson. And Mr. Henderson was previously in court. We've got 3 MTRPs and a new case, and he entered pleas of guilty, or a plea of guilty in that new case, and pleas of true to counts 1 through 6 in each of those motion to revoke probation cases. I've received a pre-sentence report, updated. Wait, is there a 5th one? Or just 4?
There's 4 cases. 3 MTLPs and
That's right, something was just printed twice. Has everyone had an opportunity to review the pre-sentence report?
Yes, Your Honor.
yes, Judge.
Are there any additions or corrections?
Not from the state.
Not from the bench.
So I'm a little, well, probably a little more than a little concerned about your ability to be successful if I put you on another probation. Because you were on probation for 2 cases, an evading and an unauthorized use of a vehicle from 2021. Then you pick up a felony theft in 2023, keep you on probation, add a probation on that case. So now you've got another felony while you're on all of these probations. And you've already been to ISF. I just need some help here. And Ms. Joseph is here. Ms. Joseph, what's your thoughts?
I believe that Mr. Henderson can satisfactorily complete his probation terms, even with the addition of another term. Mr. Henderson, from the start, and I had frank conversation with him about his current situation as well as the subsequent offense. He understands the seriousness of it, the unnecessariness of this event, and he offered no excuses, which is refreshing. When I notified him of the warrant, he did not hesitate, and he turned himself in. When I spoke with him at the correctional facility, he stated that he would accept whatever the consequences were, or would be.
Well, and another thing, Mr. Henderson, which is a bit of a breath of fresh air around here, is you have absolutely no jail reports. And with the group of young people your age out there, that is pretty amazing because they're acting like fools, aren't they?
He's been in actually for 120 days too, Judge, so it's not just a short stint.
So the recommendation is ISF again, which I'm not opposed to. I'm sorry?
A state jail sanction for 180.
Okay, that's not what it says on here.
Well, that was my recommendation.
Is there an issue with misuse of drugs?
No, it's cognitive.
Safety's,
I didn't recommend ISF, I recommended 180-day state jail.
just 180 days
Yes,
upfront
that's-
time.
He's already been to ISF,
I
so
know.
I don't know why we would repeat that, but that's why I recommend
Same, okay.
state jail.
Go get a feel for what it's like somewhere other than our
Yes,
jail.
yes. And we discussed that. I told him that's my recommendation, and he was willing to accept it.
All right. What do you think, Mr. Henderson? Do you have anything to say?
Judge, can I just say one thing briefly?
Mm-hmm.
He has been in for 120 days. He's had no write-ups. To his credit, every time I've met with him, he's accepted responsibility. He knows this is not a second chance, but a third and fourth chance that the court's giving him.
It's
He's
the
not
last
sentenced-
chance.
Yeah.
That's what it
He's
is.
not a sinister young man. He knows that he's made some really foolish mistakes, and this last thing was him doing wheelies on a dirt bike. But I do think that he is someone that can be successful in probation. I think that he realizes too that this is not the path he wants to go down. And with every report and everything he said, he's accepting responsibility.
Yeah.
He knows he's messed up. And I do think he's somebody that, Judge, I really do think we're not gonna see him again.
So, Mr. Henderson, I want you to understand, if I go along with this today and you're back in here, I'm going to see all of this and I'm going to wonder what I was thinking today. And that's not going to be good because you will be agreeing today to a certain amount of time in prison. And so we're not going to come in here and negotiate. You mess up again, you're going to be in here getting all the sentences that you're getting. Do you understand? Do you understand?
Yes, ma'am.
Okay. So what is the agreement is just to continue those probations?
Well, actually, the agreement was for ISF cognitive training.
Okay,
I realized he'd already been.
yeah. So we've got 2 deferreds on those 21 cases. 5 years. Okay, in cause number 25 DCCR 0520, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with the use of a vehicle. I'm going to sentence you in accordance with your agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections, but probate that and place you on probation for 10 years. That's what your agreement is. I am going to order a $250 fine in that case. And I am going to order that you serve 180 days upfront time. And there's not going to be credit for the time you've sat, because I want you to see what it feels like to sit somewhere other than Jefferson County Jail. All right? And cause number 21-38934. Find that you entered your pleas of true, freely, and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do so. I'm going to continue you on probation in that case. In cause number 22-39131, also find that you entered your pleas of true, freely, and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do so. I'm going to continue you on probation in that case as well. And then finally, in cause number 23 DCCR 0899, find that you entered those pleas of true, freely, and voluntarily. Find sufficient evidence to revoke your probation, but I'm not going to do so in that case either. I am going to continue that probation. Cause number 21-38934. That's the evading arrest or detention with the use of a vehicle. So that's that first evading. I am going to, I'm continuing your probation, but I am going to extend it by 2 years. All right, so that's now a 7-year probation instead of a 5. Make sure to make that note. And then the other ones, I'm going to leave that other one. Okay. All right. So I'm going to hand you the trial court certifications in each of these cases, Mr. Smith, if you don't mind. This shows these were agreements that I followed, and so you waived your right to appeal. This new case, I want to make sure, again, that we're very clear that if you violate any condition of probation from this point forward, you are looking at a 10-year sentence in the first evading, 2 years state jail in the first unauthorized use, 2 years state jail in the theft, and 10 years that you disagree to in this case. Do you understand? So it's very important that you do everything. It sounds like Ms. Joseph believes in you and that you can do what you've showed that you can follow the rules in jail and for some time out of jail, but you got to follow the rules all the time or you're going to end up in prison, and nobody wants that. All right. So take advantage of this situation. When you get out of doing your upfront time, go straight to probation, follow all of those rules, and hopefully we won't see each other here again. All right. Good luck to you. You can go back with the bailiff. 891. The state's elected to proceed on count 1 only. It alleges you committed the 3rd-degree felony offense of assault on a public servant, and that is from August 19th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? See, state tenders number 1. It's admitted. Mr. Falk, I'm going to find that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent, you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of assault on a public servant, third-degree felony, sentence you to, in accordance with your agreement, to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff. All right, are you Kevin Tran? And Mr. Tran, in clause number 2137560, 2138780, 25 DCCR 0422, 25 DCCR 0423, 25 DCCR 0424. I'm going to take judicial notice of the files in all of those cases. Looks like the first 2 cases, he's on probation, and then we've got new offenses as well. Mr. Tran was evaluated for competency to stand trial by Dr. Grapon. I received that report dated July 21st of 2025. The finding in that report is that Mr. Tran is currently not competent to stand trial, and that inpatient restoration would be called for. Is there any other evidence with regard to competency?
No, Your Honor.
All right, then based on that report at this time, I am going to find that Mr. Tran is not competent to stand trial, find that inpatient competency restoration is required, and order that he be sent to the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility, and then we'll await a report. Mr. Tran, we're going to try to get you some help so that you can understand everything that's going on, and then we'll get you back in court as soon as we can. You can go back with the bailiff. And then you've got a Michael White. Let's see. All right, you're Michael White. And this is cause number 24, DCCR 0782. And Mr. White was previously found not competent to stand trial, sent to the Dunn Behavioral Science Center. And we received a report from them dated April 4th of 2025. That report is from Samantha Guzman, and the opinion in that is that he is still not competent to stand trial, with the finding that outpatient competency restoration could potentially be something that would work for Mr. White. The problem with that is that we don't have an outpatient competency restoration program, and so and that he's not likely to achieve competency. So I don't know exactly where that leaves us. Mr. Smith, what's the?
Judge, I believe his mother lives in Florida. She's willing to take custody of him, and I believe they have a program that is along the lines of this with outpatient competency restoration.
Yeah. Would we do that through a civil, or would it be a dismissal?
That was the question I had on you. We're willing to do whatever it takes to get him there.
And Judge, if I may, I've been talking with his mother. She's been in contact with the probation department there, just trying to get familiar with what kind of programs they have. They have a program there called the Gateway Program that works with their mental health department. That's basically similar, goes along parallels to what this would be. And the only issue that they've been having to try to get information on Mike is, from my understanding, they can't do the interstate compact without it having an out date or anything from when they would be getting out to leave to go down there.
But I can't, is this a motion or is this a new case?
It's a motion, because he was sent back from ISF, Judge.
Yep.
Okay.
He was sentenced to ISF as a term and condition of the probation term.
Mm-hmm.
He got to ISF and then started to regress.
Right.
So I can, without pleas of true or not true, really, I think on that motion, I think we can just order that he live in a certain place, which would be with her, that he participate in those programs, and then the probation could transfer to that, correct? I mean, we can't do obviously any kind of pleas on anything,
No,
so
I
it would
agree.
require a dismissal of the motion to revoke.
I don't know, do we actually have a motion filed? I believe we just had this set for hearing because he was returned from ISL.
Gotcha, okay, so then we just need probation to do the, I don't know if you would necessarily take an administrative hearing or just sending me the, order to sign, ordering the gateway program through, and if you can get the county and the address of it, where his mom lives, and
I
get
got
all
her
of that.
address and that information this morning, so I
You
can
can
just
get all
go-
that to probation, does that sound like something we can do?
Our address as well.
Okay, well, let's do that then, we'll just, not go forward with anything, motions here, let's just, whatever conditions you need to add with regard to him being able to go there, and then we can kind of figure out when that's gonna happen so that
Right.
they can get transportation. So if you'll work with probation, y'all get all that worked out,
Okay,
okay?
no problem.
All right, we're gonna get it where you can go live with your mom in Florida, okay? But you still have to follow the rules. Y'all marked, second degree.
We're gonna proceed on, at least one of the priors, Judge, with the court's permission. It is not something, there are additional priors that would enhance him that are not required in the underlying, if that makes sense. Jurisdictionally, they're not required, but
Let's see, so it looks like there's two, the first two are, well, we've got to,
so he received 5 years TDC on the 93 case and then 90 days on the 98 case. And then my position is that at least that 2004 or the 2009, whichever the court would like to recite, would enhance him from the third to the second.
so he'll plead on all, let's say, except for that last one, because that would actually enhance it again.
Yes.
All right, so you'll waive, the March 3rd, 2009. We won't go on that, but everything else. Does that make sense to you too, Mr.
Yes, ma'am.
Parker? All right, sir, are you Alfredo Gayton?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
He will, Your Honor. I give you.
Mhm.
Okay.
I think so.
Yeah,
I think I already
did.
signed
I
it
did.
and
Okay.
handed it over. Give me just a second to get this pulled up. Mr. Gayton, in cause number 25 DCCR 0184, you're charged with the third-degree felony offense of driving while intoxicated, third or more, and that's for March 30th of 2024. The indictment alleges you were previously convicted of driving while intoxicated September 28th of 1993 in Harris County, Texas, and then after that, and then on July 9th of 1998, convicted of driving while intoxicated in San Patricio County, Texas. And then after that, you were convicted on July 28th of 2004, again in Harris County, of driving while intoxicated. And how do you plead to that charge?
Guilty,
And are those prior convictions true?
yes,
Did you enter your plea of guilty and true freely and voluntarily?
yes, ma'am.
And because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Now, it looks like the agreement that you've reached is for a cap of 14 years in the institutional division of the Texas Department of Corrections. I want to make sure you understand you have an absolute right to have a jury come in and determine two things. You could have that jury decide if you're guilty or not, and then you could leave your punishment up to that jury if they found you guilty. If we go forward this way, you're waiving that right, and you're leaving your punishment up to me. And as long as I don't give you more than 14 years, then you're waiving any right to appeal. Do you understand? Also, do you understand, if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Gayton is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to restate your case for sentencing so that the probation department can do a pre-sentence report That'll give me more information about you and your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Parker, and he'll present it to me on your behalf when we come back. All right? You can go back with the bailiff. Thank you. Good morning. Are you Sean Harley?
Yes, Sean.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
You will, Your Honor.
Mr. Harley, in cause number 24-2148, you're charged with the state jail felony offense of criminal mischief, and that's from August 28th of 2024. And how do you plead to that charge?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they charged you with?
Yes, Your Honor.
And then in cause number 25 DCCR 0739, you're charged with a third-degree felony offense of harassment of a public servant. That's from August 28th of 2024. And how do you plead to that charge?
Guilty, Your Honor.
Again, are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And because you did what they've charged you with?
Yes, Your Honor.
In each of these cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Harley is not competent?
No, Your Honor.
All right, Mr. Harley, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily.
Yes, Your Honor.
Find that you're mentally competent and you understand the nature and the consequences of your pleas. In cause number 24, DCCR 2148, find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of criminal mischief. Sentence you in accordance with your agreement to a term of 1 year in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25, DCCR 0739, also find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of harassment of a public servant. Sentence you in accordance with that agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I've handed you the trial court certification in each case that shows these were agreements and that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker.
Yes, Your Honor.
All right, good luck to you, sir. You can go back with the bailiff.